It's been a minute since I've provided an update on the Kei'Mani Latigue case, and I just wanted to bring you up to speed on all of the legal wranglings going on in the courtroom with Darnell Jones and the state of Ohio. September 3rd, the coroner reported to WTOL that no pregnancy was found at autopsy. However, no test was given, so early pregnancy cannot be ruled out. On that date, there was an opinion and order filed by the Judge Michael Golding. It was on the motion to dismiss capital specifications by the defense, their motion number 5. It was ruled all issues raised by defense have been rejected and the constitutionality of the capital specifications were upheld. September 9th, the defendant filed for an ex parte hearing on the indigency and motion for expert assistance. Clearly, the state has no right to know the proposed trial strategies and defenses the accused chooses to explore. Furthermore, the state has no more right to say whom the defense chooses as an expert than the defense has in the selection of the expert witnesses by the state. A non-indigent defendant would not have to share contemplated expert witnesses with the state unless he chose to call them as witnesses. Mr. Jones would be required to disclose them pursuant to Crim R16. Finally, Mr. Jones' rights against self-incrimination and to effective assistance of counsel could conceivably be jeopardized if he's forced to make his showing of reasonable necessity in the presence of the state. Consequently, Mr. Jones is entitled to an ex parte hearing on his request to appropriate funds for expert assistance. The court conducted an ex parte hearing on the motion for expert assistance on Monday, September 15th, and the subsequent order is under seal. There have been motions filed by both sides for discovery. The defendant, Darnell Jones, through his attorney, certified there was no discovery as of the date of the filing, September 15th. However, the defense seems to have been filing motions to disclose for discovery that they respectfully request Brady evidence be disclosed, and they feel as though there are some discovery issues happening in the case. Perhaps most interesting, a subpoena was served upon Lucas County Children's Services back in August, and it was set for hearing on the 19th of September. They wanted the custodian of records for Lucas County Children's Services to bring all records of agency involvement with Darnell Jones, Darnell Ogletree, Dorothy Latigue, and Kei'Mani Latigue. The state claims confidentiality, the scope is too broad. They filed a motion to quash, and LCCS is also fighting handing over those records to the defense. It encompasses thousands of pages of records, including confidential information relating to issues and persons unrelated to the subject case, due to the fact that it requests quote-unquote all records involving 3 separate individuals and a 4th alias, meaning Darnell Ogletree, Darnell. Lucas County Children's Services is seeking the protection from the subpoena, and a motion to quash was filed on September 16th. The hearing on that motion will be held on September 24th. Now, keep in mind, these are all pretrial hearings. The hearing itself is not scheduled until 2026, tentatively. Stay tuned, and I will update you as updates become available.